We back at notice of dishonor in the Bill of Exchange Act, and I'm reading from this page that's on YouTube. This guy that's reading the Bill of Exchange. I just use his background so I could read it off of his. Sometimes I gotta do that because I don't have the physical book or might not have the internet, so you gotta read it however you gotta read it. Excuse me. So, notice of dishonor 95 1. Subject to this act, when a bill has been dishonored by no non acceptance. So, subject to this act, when a bill is dishonored by non acceptance or by non payment, notice of dishonor must be given to the drawer and each endorser, and any drawer or endorser to whom the notice is not given is discharged. And subsequent holder 2, where a bill is dishonored by non-acceptance and notice of dishonor is not given, the right of a holder in due course subsequent to the omission is not prejudiced by the omission. Pardon me. Notice of subsequent dishonor 3, where a bill is dishonored by non-acceptance and due notice of dishonor is given, it is not necessary to give notice of subsequent dishonor by non-payment unless the bill is accepted in the meantime. Notice of acceptor 4. In order to render the acceptor of a bill liable, it is not necessary that the notice of dishonor be given to him. Conditions for validity of notice 96. Notice of dishonor, in order to be valid and effective, must be given A, not later than the judicial or business day next following the dishonoring of the bill. B, by or on behalf of the holder or by or on behalf of an endorser who at the time of giving notice is himself liable on the bill. C, in the case of the death, if known to the party giving notice of the drawer or endorser to a personal representative, if there is one, and with the exercise of reasonable diligence he can be found, and D, in case of two or more drawers or endorsers who are not parties or partners, who are not partners to each of them, unless one of them has authority to receive notice for the others. How notice given 97. Notice of dishonor may be given A, as soon as the bill is dishonored, B, to the party to whom notice is required to be given, or to his agent in that behalf, C, by an agent either in his own name or in the name of any party entitled to give notice, whether that party is his principal or not, or D, in writing or by personal communication and in any terms that identify the bill and intimate the bill that the bill has been dishonored by non-acceptance or non-payment. D again, in writing or by personal communication and in any terms that identify the bill and in intimate that the bill has been dishonored by non-acceptance or non-payment. Misdescription. 2. A misdescription of the bill does not vitiate the notice unless the party to whom the notice is given is in fact misled thereby. Form of notice 98. 1. In point of form, the return of a dishonored bill to the drawer or endorser is a sufficient notice of dishonor, and a written notice need not be signed. Verbal supplement. 2. An insufficient written notice may be supplemented and validated by verbal communication. Notice by agent 99. 1. Where a bill, when dishonored, is in the hands of an agent, he may himself give notice to the parties liable on the bill, or he may give notice to his principal, in which case the principal, on receipt of the notice, has the same time for giving notice as if the agent had been an independent holder. Time for notice. 2. Where the agent gives notice to his principal, he must do so within the same time as if he were an independent holder. Notice to antecedent parties. 100. Where a party to a bill receives due notice of dishonor, he has, after the receipt of the notice, the same period of time for giving notice to antecedent parties that a holder has after dishonor. Benefit of notice. 101. A notice of dishonor inures for the benefit. Inures for the benefit. And we gotta look up that word inures. Cause inures. And it says inures to operate or take effect, to serve to the use, benefit, or advantage of a person. A release to the tenant for life inures to him in reversion, that is, it has the same effect for him as for the tenant for life, often written INURE, inure, to operate or take effect. So 100A. Of all subsequent holders and of all prior endorsers who have a right of recourse against the party to whom the notice is given, where given on behalf of the holder, and B. Of the holder and all endorsers subsequent to the party to whom the notice is given, where given by or on behalf of an endorser entitled under this part to give notice. How notice addressed. 102. 1. Notwithstanding anything in this act, notice of dishonor of any bill payable in Canada is sufficiently given if it is addressed in due time to any party to the bill entitled to the notice at his customary address or place of residence, or at the place at which the bill is dated, unless any such party has under his signature designated another place, in which case the notice shall be sufficiently given if addressed to him in due time at that other place. Sufficiency of two, sufficiency of notice. Two, a notice referred to in subsection 1 shall be sufficient, although the place of residence of such party is other than either of the places mentioned in that subsection, and shall be deemed to have been duly served and given for all purposes if it is deposited in any post office with the postage paid thereon at any time during the day on which presentment has been made, or on the next following. It says juridical. You know, I think it's supposed to say judicial. Say juridical. So judicial or business day. Death of party, and that's right here, juridical. Death of party. 3. The notice referred to in subsection 1 is not invalid by reason only of the fact that the party to whom it is addressed is dead. Miscarriage in post service, where a notice of dishonor is duly addressed and posted, not mailed, posted as provided in section 102, the sender is deemed to have given due notice of dishonor, notwithstanding any miscarriage by the post office. Excuse for delay. 104. 1. Delay is given notice of dishonor is excused where the delay is caused by circumstances beyond the control of the party given notice and not imputable to his default, misconduct, or negligence. Diligence. 2. Where the cause of delay is given notice of dishonor ceases to operate, the notice must be given with reasonable diligence. Notice dispensed with. 105. 1. Notice of dishonor is dispensed with. A. When after the exercise of reasonable diligence, notice as required by this act cannot be given to or does not reach the drawer or endorser sought to be charged, or B. By waiver, express or implied. Time of waiver. 2. Notice of dishonor may be waived before the time of giving notice has arrived or after the omission to give due notice. Dispensing with notice, redrawer. 106. Notice of dishonor is dispensed with as regards the drawer where A. The drawer and drawee are the same person. B. The drawee is a fictitious person or a person not having capacity to contract. C. The drawer is a person to whom the bill is presented for payment. D. The drawee or acceptor is, as between himself and the drawer, under no obligation to accept or pay the bill. Or E. The drawer has countermanded payment. Dispensing with notice. D. Notice re-endorser. Dispensing with notice re-endorser. 107. Notice of dishonor is dispensed with as regards the endorser were A. The drawee is a fictitious person or a person not having capacity to contract, or the endorser was aware of the fact at the time he endorsed the bill. B. The endorser is a person to whom the bill is presented for payment, or C, the bill was accepted or made for his accommodation. Protest. Necessity of Protest. 108. In order to render the acceptor of a bill liable, it is not necessary to protest it. Protest dispensed with. 109. Protest is dispensed with by any circumstances that would dispense with notice of dishonor. Delay excused. 110. 1. Delay in noting or protesting is excused where the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. Diligence. 2. Where the cause of delay in noting or protesting ceases to operate, the bill must be noted or protested with reasonable diligence. Foreign bill non-acceptance. 111. 1. Where a foreign bill appears on the face of it to be such has been dishonored by non-acceptance, it must be duly protested for non-acceptance. Non-payment. 2. Where a foreign bill that has not been previously dishonored by non-acceptance is dishonored by non-payment, it must be duly protested for non-payment. Balance. 3. Where a foreign bill has been accepted only as to part, it must be protested as to the balance. Discharge. Where a foreign bill is not protested as required by this section, the drawer and endorsers are discharged. Protest of inland bill. 112. Where an inland bill has been dishonored, it may, if the holder thinks fit, be noted and protested for non-acceptance or non-payment, as the case may be, but it is not necessary to note or protest an inland bill in order to have recourse against the drawer or endorsers. Protests are necessary where a bill does not, on its face of it, appear to be a foreign bill. Protest thereof in case of dishonor is unnecessary. Subsequent protest for non-payment. 114. A bill that has been protested for non-acceptance, or a bill of which protest for non-acceptance has been waived, may be subsequently protested for non-payment. Protest for better security. 115. Where the acceptor of a bill suspends payment before it matures, the holder may cause the bill to be protested for better security against the drawer or endorsers. Acceptance for honor. 116. 1. Where a dishonored bill has been accepted for honor under protest or contains a reference in case of need, it must be protested for non-payment before it is presented for payment to the acceptor for honor or referee in case of need. Protest of non-payment. 2. When a bill is dishonored by the acceptor for honor, it must be protested for non-payment by him. Noting equivalent to protest. 117. For the purpose of this act, where a bill is required to be protested within a specified time and before some further proceeding is taken, it is sufficient that the bill has been noted for protest before the expiration of the specified time or the taking of the proceeding. Protests on date of dishonor. 118. 1. Subject to this act, when a bill is protested, the protest must be made or noted on the date of its dishonor. Subject to this act, when a bill is protested, the protest must be made or noted on the date of its dishonor. Extending protest. When a bill has been duly noted, the formal protest may be extended thereafter at any time as of the date of the noting. Protest on copy or particulars. 119. Where a bill is lost or destroyed or is wrongly or accidentally detained from the person entitled to hold it, or is accidentally retained in a place other than where payable, protest may be made on a copy or written particulars thereof. Place of protest. 121. A bill must be protested at the place where it is dishonored, or at some other place in Canada situated within 5 miles of the place of presentment and dishonor of the bill. The place of presentment and dishonor of the bill. Where bill returned by post. Where bill returned by post. 2. When a bill is presented through the post office and returned by post dishonor, it may be protested at the place to which it is returned, not later than on the day of its return or the next jurisdictional day. Judicial. Time of protest. 3. Every protest for dishonor, either for non-acceptance or non-payment, may be made on the day of the dishonor, and in case of non-acceptance, at any time after non-acceptance, and in case of non-payment, at any time after 3 o'clock in the afternoon, local time. Contents of protest. 121. A protest must contain a copy of the bill, or the original bill may be annexed thereto, must be signed by the notary making it, and must specify a. the person to whose request the bill is protested, b. the place and date of protest, c. the cause and reason for protest, and d. the demand made and the answer given, if any, or the fact that the or the fact that the drawee or acceptor could not be found when notary not accessible. 122. Where a dishonored bill is authorized or required to be protested and the services of a notary cannot be obtained at the place where the bill is dishonored, any justice of the peace resident in the place may be present and protest the bill and give all necessary notices, and has all the necessary powers of a notary in respect thereto. Expense. 123. 1. The expense of noting and protesting any bill and the postages thereby incurred shall be allowed and paid to the holder in addition to any interest thereon. Notary fee. 2. Notaries may charge the fee in each province allowed them. Forms. 124. 1. The forms in the schedule may be used in noting and protesting any bill and in giving notice thereof, annexing copy or original of bill. 2. A copy of the bill and endorsement may be included in the forms, or the original bill may be annexed and the necessary changes in that behalf made in the forms. How notice of protest given? 125. Notice of the protest of any bill payable in Canada is sufficiently given and is sufficient and deemed to have been duly given and served if given during the day on which protest has been made or on the next following judicial or business day to the same parties and in the same manner and addressed in the same way as is provided by this part for notice of this honor. When we come back, we're gonna get to liabilities of parties. Liabilities of parties when we get back.